Chapter 21 Human Rights and Fair Housing Introduction. Objectives. In this chapter, we will discuss the discrimination laws that licensees must know and follow. At the end of this chapter, you will be able to 1. Cite and describe principal federal fair housing laws, their central thrust, how they are enforced, and the general responsibilities these laws impose on brokerage practice. 2. Describe additional fair housing laws, particularly New York's human rights law, and the central thrusts of this legislation. 3. Explain the nature of various forms of discrimination in lending and brokerage and how testers contribute to enforcement of anti-discrimination laws. 4. Describe specific ways licensees can conduct their practice to avoid discrimination and reduce their exposure to related liabilities. Key terms. There are a number of important terms in this chapter. Remember to pay particular attention to these terms when you see them. Americans with Disabilities Act. Jones v. Mayer Supreme Court Decision 1968. Blockbusting. Marital status. Cease and desist list. New York State Human Rights Law. Civil Rights Act of 1866. Non-Solicitation Order. Disability or Handicap. Redlining. Fair Housing Act of 1968. Steering. Familial status. Testers. Filtering down. At Department of Housing and Urban Development. Click here to complete your New York Real Estate Licensing Law reading assignment. Title 19, Subchapter D, Sections 175.17, 178. The New York Bureau of Educational Standards requires that you spend 200 minutes studying the material in this chapter. Your course timer can be found in the upper right-hand corner of your screen. Introduction. When it comes to fair housing, real estate licensees have both an ethical and a legal responsibility to their clients and customers. Civil rights laws in the real estate industry are designed to create a situation in which persons having similar financial means will have similar choices when attempting to buy, lease, rent, or finance property. The laws are also designed to allow everyone an opportunity to live in the place of his or her choice by creating an open and unbiased market. Due to the civil rights movement that began in the 1960s, many people today believe that fair housing is no longer an issue. However, even with the passage of laws that provide equal housing opportunities, we still have not achieved this goal. Some examples of discrimination that we still see today include landlords and sellers requesting only specific types of persons be shown their homes and apartments. Sellers showing concern over what their neighbors would say or do if a minority person or family were to move in. Buyers and renters making derogatory statements about parts of the community. Buyers and renters asking very pointed and discriminatory questions about aspects of the neighborhood. Buyers and renters refusing to view properties in parts of the community where certain people live. Even though you will encounter these types of situations, it's important for you to understand what real estate licensees can and must do to manage them. Brokers' responsibility. Brokers have a responsibility to comply with fair housing policies. They must maintain a fair housing office. A broker should take these steps to ensure compliance with fair housing laws. Follow the suggestion of the National Association of Realtors registered trademark and post a sign which states that it is against company policy as well as state and federal laws to offer any information on the racial, ethnic or religious makeup of a neighborhood or to restrict the listing, showing or giving of information on the availability of homes for any of those reasons. Prominently display in all offices the Equal Opportunity poster that the Department of Housing and Urban Development distributes. Click here to open and print the Equal Opportunity poster. Equal Housing Opportunity poster. Maintain the concept of fair housing in all forms of advertising. Provide ongoing training and education to all affiliated licensees by holding seminars and workshops, watching videos and bringing in guest speakers. Appropriate training is also available through NER, state and local boards and real estate schools. Please review the real estate broker and salesperson discriminatory practice notice posted on the Division of Licensing Services website. This document provides guidance regarding fair housing practices and discrimination, a link to the Department of State's website and a link to the New York State Division of Human Rights Fair Housing Guide. More responsibilities. Brokers should also do the following. Report blatant misconduct by other licensees. This can prove to be a very uncomfortable situation for a broker, but when violations are obvious, the behavior should be reported to the proper authority. Put a system in place to monitor the activities of all affiliated licensees with regard to fair housing compliance. Ask licensees to keep records of all prospects, their qualifying information and the prospects' reactions to the property they were shown. Review the records periodically to help identify any situations where the licensee may be in violation of fair housing issues. Include a fair housing policy for their office in the Policy and Procedures Manual. Salesperson's responsibility. Licensees share in the responsibility of complying with fair housing laws. Licensees should know the fair housing laws and their responsibilities for compliance. Act in accordance with the law at all times. Learn to keep clear and accurate records. Attend fair housing training seminars periodically. Know the resources to use if misconduct needs to be reported. Note: the Department of State requires licensees to complete 3 hours of continuing education in fair housing and discrimination as part of the 22.5-hour continuing education requirement. Now let's begin our discussion about the federal fair housing laws themselves. Fair housing law. Important legislation. Fair housing law first began with the Civil Rights Act of 1866, which prohibited discrimination in housing based on race. However, at that time the federal government did not provide solutions, and the individuals involved had to provide their own remedies. Because those being discriminated against had limited access to legal help, many victims of discrimination were left without recourse. Since the last half of the 20th century, there have been an increasing number of remedies provided under this act. Title 8 of the Civil Rights Act of 1968, also known as the Fair Housing Act of 1968, prohibited discrimination in housing based on race, color, religion or national origin. In 1968, in a landmark decision, the Supreme Court in Jones v. Mayer ruled that discrimination on the basis of race is strictly prohibited. This means there can be no exemptions or exceptions with regard to race. Title 6 of the Civil Rights Act of 1964 was enacted to prohibit discrimination on the basis of race, color, or national origin in programs and activities receiving federal financial assistance. In 1974, the Housing and Community Development Act added sex to the list of protected classes. And in 1988, the Fair Housing Amendments Act added handicap and familial status. Fair housing law. Important legislation based on these laws. The list of protected classes of the Federal Fair Housing Act are: race, religion, color, national origin, sex, handicap, familial status. 1988 amendments. As we said, the 1988 amendments added handicap and familial status to the list of protected classes. Let's look more closely at these protections. Disability or handicap. If a person has a physical or mental disability or handicap, including hearing, mobility and visual impairments, chronic alcoholism, chronic mental illness, AIDS-related complex and mental retardation that substantially limits one or more major life activities, has a record of such a disability or is regarded as having such a disability, a property owner may not refuse to let the person make reasonable modifications to the dwelling or common use areas, at his or her expense, so he or she can use the housing. Refuse to make reasonable accommodations in rules, policies, practices or services, if necessary for the disabled person to use the housing. For example, A building with a no pets policy must allow a visually impaired tenant to keep a guide dog. Requirements for new buildings and buildings that are ready for first occupancy after March 13, 1991, and have an elevator and 4 or more units. Public and common areas must be accessible to persons with disabilities. Doors and hallways must be wide enough for wheelchairs. All units must have all of the following: an accessible route into and through the unit, accessible light switches, electrical outlets, thermostats and other environmental controls, reinforced bathroom walls to allow later installation of grab bars, kitchens, and bathrooms that can be used by people in wheelchairs if a building with 4 or more units has no elevator and will be ready for first occupancy after March 13, 1991. These standards apply to ground floor units. These requirements for new buildings do not replace stricter standards that apply in state or local law. 1988 Amendments for familial status. Unless a building or community qualifies as housing for older persons, it may not discriminate based on familial status. That is, it may not discriminate against families in which 1 or more children under 18 live with one of the following persons: a parent, a person who has legal custody of the child or children, the designee of the parent or legal custodian, with the parent or custodian's written permission. Familial status protection also applies to pregnant women and anyone securing legal custody of a child under 18. Exemption: housing for older persons is exempt from the prohibition against familial status discrimination if one of the following conditions exists. The HUD Secretary has determined that it is specifically designed for and occupied by elderly persons under a federal, state or local government program. It is occupied solely by persons who are 62 or older. It houses at least one person who is 55 or older in at least 80% of the occupied units, and adheres to a policy that demonstrates the intent to house persons who are 55 or older. Fair housing enforcement. The Federal Fair Housing Act is administered by the Office of Fair Housing and Equal Opportunity under the direction of the Secretary of Housing and Urban Development. Any person who believes he or she has been discriminated against may file a complaint with HUD within 1 year of the alleged act. HUD can also initiate a complaint on its own. When HUD receives a complaint, it will start an investigation. Within 100 days, HUD will determine if there is reasonable cause to charge discrimination, or it will dismiss the complaint. During the investigation period, HUD can attempt to resolve the complaint by getting assurance from the person against whom the complaint was filed that he or she will remedy the alleged violation. This is called conciliation. A conciliation agreement must protect both the person filing the complaint and the public interest. If an agreement is signed, HUD will take no further action on the complaint. However, if HUD has reasonable cause to believe that a conciliation agreement is breached, HUD will recommend that the Attorney General file suit. Fair housing enforcement. If the case goes to an administrative hearing, HUD attorneys will litigate the case for the person filing the complaint. That person may intervene in the case and choose to be represented by his or her own attorney. An administrative law judge will consider evidence from both the complainant and the respondent. If the AL decides that discrimination occurred, the respondent can be ordered to compensate for actual damages, including humiliation, pain, and suffering. To provide injunctive or other equitable relief, for example, to make the housing available to the complainant. To pay the federal government a civil penalty to vindicate the public interest. The maximum penalties are $10,000 for a first violation and $50,000 for a third violation within 7 years. To pay reasonable attorney's fees and costs. In addition to, or instead of filing a complaint with HUD, a person may file a suit in a state or federal court within 2 years of the alleged violation. If the court finds that discrimination has occurred, the person filing the complaint may be entitled to actual damages, punitive damages, attorney's fees and costs. Check your understanding. Print this screen, answer the questions and then advance to the next screen to see the answers. 1. List 2 steps a broker should take to ensure compliance with fair housing laws. 2. What is significant about the Fair Housing Amendments Act of 1988? 3. Describe the exemption that exists for familial status discrimination. 4. If a person feels like he or she has been discriminated against, how long does that person have to file a complaint? Check your understanding. Answers 1. List 2 steps a broker should take to ensure compliance with fair housing laws. Prominently display in all offices the Equal Opportunity poster that HUT distributes. Provide ongoing training and education to all affiliated licensees by holding seminars and workshops, watching videos and bringing in guest speakers. 2. What is significant about the Fair Housing Amendments Act of 1988? It added handicap and familial status to the list of protected classes. 3. Describe the exemption that exists for familial status discrimination. Housing for older persons is exempt if one of the following conditions exists. The HUD Secretary has determined that it is specifically designed for and occupied by elderly persons under a federal, state or local government program. It is occupied solely by persons who are 62 or older. It houses at least one person who is 55 or older in at least 80% of the occupied units, and adheres to a policy that demonstrates the intent to house persons who are 55 or older. 4. If a person feels like he or she has been discriminated against, how long does that person have to file a complaint? With HUD, within 1 year of the alleged act in state or federal court, within 2 years of the alleged act other federal laws. These federal laws played an important role in helping to shape American civil rights policy after the passage of the original Civil Rights Act of 1866. Plessy v. Ferguson. This Supreme Court decision allowed the use of separate but equal, racially segregated accommodations and facilities. In other words, as long as separate housing for blacks and whites were judged to be equal, they were legal. Buchanan v. Worley. In the city of Louisville, Kentucky, a state law prohibited blacks from living in neighborhoods where the majority of homes were occupied by whites, and also restricted whites from residing in majority black neighborhoods. A white seller sued a black purchaser who claimed that their contract was void because the law barred him from buying the home. The Supreme Court held that the law violated the 14th Amendment and therefore was unconstitutional. The court reasoned that while the objective may have been legitimate, laws cannot deny rights protected by the Constitution. Brown v. Board of Education. In this landmark case, the Supreme Court prohibited racial segregation of public schools. The court said that the separate but equal doctrine adopted in Plessy v. Ferguson had no place in the field of public education. Americans with Disabilities Act. Another important piece of legislation that licensees should become familiar with is the Americans with Disabilities Act, which became effective in 1992. ADA mandates that persons with disabilities have equal access to jobs, public accommodations, government services, public transportation, and telecommunications. It prohibits discrimination in the full and equal enjoyment of goods and services provided by public places, including hotels, shopping centers and offices, and it applies to the lease and operation of commercial facilities. Since most real estate firms are public places, they fall into ADA's definition of a public accommodation. Brokers should evaluate how this applies to physical changes they might need to make to their office space to accommodate both employees and clients. In addition, licensees should alert their commercial and investor clients to the existence of the law and the need to have their leases professionally evaluated and their offices inspected for compliance. The owner of a commercial property might have to make changes to a building to bring it into ADA compliance. Such changes might include adding ramps to the front entrance or accessible parking spaces, widening doorways or aisles, installing elevators, improving restroom facilities by adding wider stalls, higher toilets or grab bars. Violations. The Department of Justice may file lawsuits in federal court to enforce the ADA, and courts may order compensatory damages and back pay to remedy discrimination if the department prevails. The Department of Justice may also obtain civil penalties of up to $55,000 for the first violation and $110,000 for any subsequent violation. Americans with Disabilities Act. It's important for investors and commercial clients to understand the impact of the ADA. Owners of small businesses that serve the public must remove physical barriers that are readily achievable, which means easy to accomplish without much difficulty or expense. The readily achievable requirement is based on the size and resources of the business, so larger businesses with more resources are expected to take a more active role in removing barriers than small businesses. The ADA also recognizes that economic conditions vary. When a business has resources to remove barriers, it is expected to do so. But when profits are down, barrier removal may be reduced or delayed. Barrier removal is an ongoing obligation. The owner is expected to remove barriers in the future as resources become available. New construction and renovation. If a client is planning to build a new facility or modify an existing one, he or she needs to consult the ADA standards for the specific requirements. Renovations or modifications are considered to be alterations when they affect the usability of the space. Examples would be installing a new display counter, replacing fixtures or flooring, or replacing an entry door. However, simple maintenance such as repainting a wall is not considered an alteration by the ADA. A model home in a real estate development is not normally required to comply with the ADA. However, if the home is also the development's sales office, the area where the sales are conducted must comply with ADA since it is a public accommodation. Note: many communities also have state or local accessibility codes enforced by local building inspectors. When a local accessibility code exists, the owner must follow both the code and the ADA requirements. New York State law. New York is the first state in the United States to enact a human rights law, which affords every citizen an equal opportunity to enjoy a full and productive life. The New York State Division of Human Rights was created to enforce this important law. Article 15 of the NYS Human Rights Law prohibits discrimination in employment, housing, credit, places of public accommodations, and educational institutions. In addition to the classes protected under the federal laws, New York has added other protected classes. Age: persons 18 years of age or older. Marital status: persons who are married or divorced. Military status: a person's participation in the military service of the United States or the military service of the state. Sexual orientation: heterosexuality, homosexuality, bisexuality or asexuality, whether actual or perceived. According to NYS human rights law, it is unlawful discrimination for an owner, lessee, assignee, managing agent, or other person having the right to sell, rent or lease a housing accommodation to refuse to sell, rent, lease or otherwise to deny to or withhold from any person or group of persons such a housing accommodation because of the race, creed, color, national origin, sexual orientation, military status, sex, age, disability, marital status, or familial status of that person. It is also unlawful to represent that any housing accommodation or land is not available for inspection, sale, rental or lease when in fact it is available. New York State law. New York State law also protects persons from retaliation with regard to discrimination charges. In other words, persons who file complaints, as well as their witnesses, are protected under the human rights law. Exemptions. Since the Civil Rights Act of 1866 permits no exceptions based on race, New York also prohibits any racially based discrimination. However, New York State does allow some exemptions. The New York exemptions include the following: the rental of an apartment in a two-family home that is owner-occupied. Restriction of all rooms that are rented to members of the same sex. Rental of a room or rooms in a person's own home. Restriction of rentals to persons 55 years of age or older and their spouses. Real estate brokers and salespersons may not participate in the exemptions above except for the one that deals with restricting the sale, rental, or leasing of property to senior citizens. Discrimination regarding obtaining credit. New York human rights law also prohibits discrimination in the obtaining of credit. The law states that it is unlawful for a creditor, officer, agent, or employee to discriminate when dealing with applications for credit to purchase, acquire, construct, rehabilitate, repair or maintain any housing accommodation, land or commercial space. The applicant cannot be discriminated against because of his or her race, creed, color, national origin, sexual orientation, military status, age, sex, marital status, disability, or familial status. In addition, the law protects stockholders, directors, officers or employees of the applicant and the prospective occupants or tenants of the housing, land, or commercial space. The unlawful discrimination pertains to the granting, withholding, extending or renewing, or in the fixing of the rates, terms or conditions of the credit. The law also prohibits the following: use of an application form which asks questions about or keeps records of a person's status as a member of a protected class. For example, a creditor could not use a form which requires an applicant to indicate if he or she is married, or asks for the applicant's age or religion. Making any inquiry of an applicant concerning his or her capacity to reproduce, or his or her use or advocacy of any form of birth control or family planning. Refusing to consider sources of an applicant's income or to subject an applicant's income to discounting, in whole or in part, because the applicant belongs to one of the protected classes. New York state law, enforcement and penalties. Any person who believes that he or she has been a victim of discrimination can file a complaint with the New York Division of Human Rights within 1 year of the alleged discrimination. Complaint forms are available for download from the DHR website. Investigative procedure. The regional office will do the following: 1. Notify the respondent after receiving the complaint of discrimination. 2. Resolve any questionable issues of jurisdiction. 3. Forward, upon the complainant's request, a copy of the complaint to the Equal Employment Opportunity Commission or the U.S. Department of Housing and Urban Development. 4. Investigate the complaint through appropriate methods, such as written inquiry, field investigation, investigatory conference, etc. 5. Determine whether or not there is probable cause to believe that an act of discrimination has occurred and notify both the complainant and the respondent in writing. If there is a finding of no probable cause, or lack of jurisdiction, the matter is dismissed and the complainant may appeal to the state Supreme Court within 60 days. New York state law, enforcement and penalties. Public hearing. In the case of a public hearing, the procedure is as follows. 1. A division attorney or agent will present the case in support of the complaint, or the complainant may elect to retain outside counsel. 2. A notice of hearing will be issued. The case may be adjourned only for a good cause. 3. An administrative law judge will preside over the hearing, which may last 1 or more days. 4. A recommended order is prepared and sent to the parties for comment. 5. A commissioner's order either dismisses the complaint or finds discrimination. If discrimination is found, the commissioner may order the respondent to cease and desist and take appropriate action. The division may order damages and/or back pay. The order may be appealed by either party to the state Supreme Court within 60 days. Within 1 year, the Compliance Investigation Unit will investigate whether the respondent has complied with the provisions of the order. New York City Commission on Human Rights. The New York City Human Rights Law is one of the most comprehensive civil rights laws in the nation. Like the New York state law, this law prohibits discrimination in employment, housing and public accommodations based on race, color, creed, age, national origin, sex, familial status, sexual orientation, disability, and marital status. Note: This law expands gender to include gender identity and sexual harassment. In addition, the Commission has identified 3 other protected groups. Alien age or citizenship status refers to the citizenship of any person or the immigration status of any person who is not a U.S. citizen or national. Lawful occupation refers to any lawful trade, occupation, profession or specialization. Partnership status refers to persons who cohabitate without being legally married. As with the other protected groups, persons cannot be denied housing because of their citizenship status, partnership status or because of what they lawfully do for a living. Exemptions. This law does not extend to residents of 2-family houses if the owner or a member of the owner's family resides in one of the housing accommodations and the available housing accommodation was not advertised. In addition, a person is not covered by the law if he or she rents a room or rooms in non-government assisted housing where the owner resides. Check your understanding. Print this screen, answer the questions and then advance to the next screen to see the answers. 1. What was the significance of the Plessy v. Ferguson Supreme Court decision of 1896? 2. Why is it important for licensees to understand the Americans with Disabilities Act? 3. What protected class or classes does New York State have in addition to those recognized by federal fair housing laws? 4. Alex Jones owns a duplex and lives in one unit. He refuses to rent the other unit to families with children. What would you say about Alex's actions? Check your understanding. Answers 1. What was the significance of the Plessy v. Ferguson Supreme Court decision of 1896? This Supreme Court decision allowed the use of separate but equal, racially segregated accommodations and facilities. In other words, as long as separate housing for blacks and whites were judged to be equal, they were legal. 2. Why is it important for licensees to understand the Americans with Disabilities Act? Brokers need to evaluate whether they need to make physical changes to their office space to comply with the law. Licensees should inform their commercial and investor clients of the need to have their leases professionally evaluated and their offices inspected for compliance. 3. What protected class or classes does New York State have in addition to those recognized by federal fair housing laws? Age, marital status, military status, sexual orientation. 4. Alex Jones owns a duplex and lives in one unit. He refuses to rent the other unit to families with children. What would you say about Alex's actions? Alex is within the guidelines of the New York Fair Housing Law since he is the owner of a 2-family dwelling, one of which is owner-occupied. Types of discriminatory behavior. Discriminatory activities in real estate include refusing to sell, rent or negotiate with any person who is a member of a protected class. Changing terms, conditions or services for different individuals as a means of discrimination. Stating or advertising that the property is restricted. Telling persons that a property is not for sale or rent when it is. Denying membership in any multiple listing service or any broker's organization. Using discriminatory advertising. Discrimination in mortgage lending. These practices are also considered discriminatory. Refusing to give a loan. Refusing to provide loan information. Giving different terms for loans, such as interest rates or fees. Discriminating when doing a property appraisal. Refusing to purchase a loan. Setting different conditions for a loan purchase in mortgage lending. Keep in mind that it is also illegal to threaten, coerce, intimidate, or interfere with anyone exercising a fair housing right or assisting others who exercise that right. Advertise or make any statement that indicates a limitation or preference based on race, color, national origin, religion, sex, familial status, or handicap. This prohibition against discriminatory advertising applies to single-family and owner-occupied housing that is otherwise exempt from the Fair Housing Act. Types of discriminatory behavior. Fair housing laws also prohibit these activities. Blockbusting, making a profit by inducing owners to sell by telling them that persons of a protected class are moving into the neighborhood, which will have detrimental results, such as the lowering of the property values, an increase in criminal behavior, or a decline in the quality of the schools in the area. Blockbusting, also called panic peddling or panic selling, includes subtle as well as obvious actions or inducements. Steering, channeling home buyers toward or away from homes in certain neighborhoods in order to preserve or alter the makeup of that neighborhood. Some examples of steering would be showing a white couple properties in areas that are occupied only by other whites, or showing African American buyers homes that are in integrated areas or areas occupied only by African Americans. Redlining, restricting the number of loans in certain areas of a community because of its racial or ethnic makeup. The usual justification for redlining is that the lender wants to limit the risks in a deteriorating area. The lender then discriminates against the whole class of risks rather than distinguishing among the individual risks. In an effort to help lenders meet the needs of the persons in their respective communities, including low-income persons, the Community Reinvestment Act requires the periodic evaluation of a lender's lending record. In a process known as filtering down, dwellings that were formerly occupied by middle and upper-income families decline in quality and value and become available to lower-income families. Lenders are encouraged to make loans on these properties to lower-income families to prevent the deterioration of the community. Advertising awareness. Compliance with anti-discrimination laws is critical when doing advertising. Discriminatory advertising is defined as advertising that indicates a preference, limitation, or discrimination based on race, color, religion, handicap, sex, familial status, or national origin. But it is sometimes difficult to know what actually constitutes discriminatory advertising. It is probably safe to say that any advertising that describes the property would be considered acceptable, while advertising that describes buyers could be considered discriminatory, especially if the buyers are from a protected class. Let's talk about some of the protected classes in a bit more detail. Race, color, or national origin. If a licensee uses words that describe the housing, the current or potential residents, or the neighbors or neighborhood in racial or ethnic terms, he or she will create liability for discriminatory advertising. For example, phrases such as white family home or no Irish are discriminatory. However, if the licensee creates ads which are racially neutral, he or she will have no liability. For example, phrases such as master bedroom, rare find, or desirable neighborhood are not considered discriminatory. Advertising awareness. Religion. If a licensee creates an ad which is explicit in its preference for or limitation of any particular religion, the ad is discriminatory. For example, licensees should never use phrases such as no Jews or Christian home. Advertisements which use the legal name of an entity which contains a religious reference or ads which contain a religious symbol, standing alone, may designate a religious preference. For example, the name Roselawn Catholic Home or a picture of a cross could imply a preference for someone of that religion. However, if the licensee uses a disclaimer in the ad, such as a statement "This home does not discriminate on the basis of race, color, religion, national origin, sex, handicap, or familial status," this ad may not be considered discriminatory advertising. If a licensee creates an ad which contains descriptions of properties or services which do not indicate a preference for the kind of person who would use those facilities, the ad would not be considered discriminatory. For example, phrases such as apartment complex with chapel or kosher meals available are not discriminatory. Note: a licensee can use common terms that relate to religious holidays, such as Santa Claus, the Easter Bunny, or St. Valentine's Day, or phrases such as Merry Christmas and Happy Easter without violating discrimination laws. Advertising awareness. Sex. If a licensee writes an ad for a single-family home or a separate unit in a multi-family dwelling, the ad must not have an overt preference for or limitation of any person that is based on gender. For example, an ad should never read males only, men only, women only, females only or other like phrases, unless the ad is describing shared living areas or homes used exclusively as dormitories by educational institutions. There are some terms that may appear on their face to be a reference to sex, but since they are commonly used as physical descriptions of housing units, they are not considered discriminatory advertising. For example, terms such as mother-in-law suite and bachelor apartment fall into the category of non-discriminatory terms. Also, the term master bedroom is not a violation of either the gender or race discrimination provisions, so it too can be used freely. Advertising awareness. Handicap. A licensee should never write a real estate advertisement which contains explicit exclusions, limitations or other indications of discrimination based on handicap. For example, phrases such as no wheelchairs, able-bodied persons only, no deaf, or no handicap parking are considered to be discriminatory. On the other hand, advertisements that include descriptions of the property, services or facilities, or neighborhoods are not considered discriminatory advertising. For example, a licensee could use phrases such as great view, fourth floor walk-up, walk-in closets, jogging trails, and walk to bus stop without violating anti-discrimination laws. A licensee could also describe in an ad the conduct that is required of residents without it being viewed as discriminatory. For example, a licensee could use the phrases non-smoking or sober. It is also within the law to write an ad that gives descriptions of accessible features, such as wheelchair ramp. Advertising awareness. Familial status. As we've seen with the other protected classes, when writing an ad, a licensee should never state a precise preference, limitation or discrimination that is based on familial status. Advertisements may not contain limitations on the number or ages of children, or state a preference for adults, couples or singles. For examples, a licensee should never use phrases such as couples only, empty nesters, single person, no families, mature individuals, or senior discount. As we discussed on the previous screen, advertisements that include descriptions of the property, services or facilities, or neighborhoods are not considered discriminatory advertising. For example, a licensee could use phrases such as two-bedroom, cozy, family room, no bicycles allowed, or quiet streets without violating anti-discrimination laws. In light of what we have just discussed, it's important for licensees to view any advertising from the perspective of all the protected classes. When composing advertising, licensees should ask themselves how they would feel if they were a member of a minority and were reading the ad. This is a good guideline to help in determining whether or not the licensee should publish the ad. More on advertising. As you have just seen, it can be a challenge to create advertising that does not use some discriminatory words or phrases. Words that are not generally recognized as being discriminatory can still be perceived as being so it's important to become familiar with those phrases that you should avoid. In 1995, the Department of Housing and Urban Development, which enforces fair housing laws, sent some guidelines to its staff to help them when investigating allegations of discrimination. The memo addressed some words and phrases which are not acceptable to use and others which, if used, would not constitute a violation or be considered discriminatory. The HUD memo addressed only a small set of possibilities, but it seems to indicate that the staff should not move complaints forward if the ads appeared reasonable and did not favor or disfavor a protected group. Organizations have published lists of words to help write ads that will not be discriminatory. One particularly good list was compiled by the Miami Valley Fair Housing Center, Inc. in Dayton, Ohio. Click on the link below to see the list. You can print a PDF copy of the list from a link on the site. Fair Housing Advertising Word and Phrase List. More on advertising. Newspaper ads comprise a large percentage of the advertising done by real estate licensees. It's important that newspaper ads do not give so much as a hint of discrimination, even unintentionally. Here are some guidelines to follow. Be sure to use a wide variety of newspapers, so that you don't give an impression of racial steering. For example, if you list a home in a predominantly minority neighborhood, be sure to advertise in a citywide newspaper and not just that neighborhood's weekly newspaper. When using pictures of people in your advertising, be sure the pictures show that the housing is open to everyone. For example, don't use all white people in an ad if the area's population is 32% non-white. Use the Equal Opportunity logo or slogan in all of your advertising. In addition, as we said earlier, a broker should have the Equal Opportunity poster displayed prominently in all of his or her offices. Check your understanding. Print this screen, answer the questions and then advance to the next screen to see the answers. 1. List 3 activities that are considered discriminatory in real estate. 2. Salesperson Sally tells her senior citizen buyers that the home they want to view is located in a neighborhood with several small children and loud teenagers. She tells them they would not be comfortable in this home, and she shows them a list of homes in other neighborhoods she thinks would be more appropriate. What would you say about Sally's behavior? 3. What is blockbusting? 4. Give 4 examples of words or phrases that would be considered discriminatory, and 3 that would not, with regard to handicap when writing an ad. Check your understanding. Answers 1. List 3 activities that are considered discriminatory in real estate. Refusing to sell, rent or negotiate with any person who is a member of a protected class. Telling persons that a property is not for sale or rent when it is. Denying membership in any multiple listing service or any broker's organization. 2. Salesperson Sally tells her senior citizen buyers that the home they want to view is located in a neighborhood with several small children and loud teenagers. She tells them they would not be comfortable in this home, and she shows them a list of homes in other neighborhoods she thinks would be more appropriate. What would you say about Sally's behavior? Sally is guilty of steering, which is prohibited by fair housing laws. 3. What is blockbusting? Blockbusting is making a profit by inducing owners to sell by telling them that persons of a protected class are moving into the neighborhood, and that it will have detrimental results. 4. Give 4 examples of words or phrases that would be considered discriminatory, and 3 that would not, with regard to handicap when writing an ad. Discriminatory: no wheelchairs, able-bodied persons only, no deaf, or no handicapped parking. Non-discriminatory: 4th floor walk-up, walk-in closets, wheelchair ramp. Testers: private fair housing groups, along with government agencies, have developed an investigative tool to uncover housing discrimination. This tool, known as testing, is defined as a simulated housing transaction designed to obtain evidence of differential treatment based on an individual's protected class status. Basically, what this means is that testers with similar profiles and housing needs, but different in their protected class status, visit a real estate office and ask to see the same available unit to ascertain if they are treated differently because of this protected class status. Testers report their findings directly to HUD, who informs the broker. Testing, coupled with good documentation and record keeping, can also clearly demonstrate a real estate agency's innocence when faced with a fair housing complaint. Dealing with testers. The Supreme Court has ruled that testing is legal. Testing for fair housing compliance must be recognized as a risk and a cost of doing business. If you think you are being tested, be aware of the following. 1. Do not attempt to frustrate the tester. 2. Treat the tester as any other buyer you encounter, even if you know you are being tested. 3. Respond only to the questions asked and never volunteer information concerning any fair housing violation. 4. It is naive to think you have the ability to know if someone is or is not a tester. It is always best to treat all of your prospects as testers. Providing all prospects with equal professional services will keep everyone free from jeopardy. 5. A tester does not have to admit what he or she is doing or identify the fact that he or she is a tester. What testers look for. While you may be sure you are being tested by a particular person, You should never try to determine if that is the case. If you treat everyone the same, you will not have any problems complying with the fair housing laws. For your information, let's look at some of the issues that are of interest to testers. Issue 1. When the tester entered the office, which of the following actions took place? Greeted by a secretary or receptionist and referred to a salesperson. Greeted by a secretary or receptionist and referred to someone else. Greeted by a salesperson and interviewed by the same salesperson. Greeted by a salesperson and referred to someone else. Greeted by a person identified as the manager or head of the firm and then referred to someone else. Required to make the first approach and then greeted. Ignored, even after making the first approach. Other. What testers look for. Issue 2. From the time the tester entered the office, how long did he or she wait to be interviewed? Less than 5 minutes. 5 minutes or more but less than 10 minutes. 10 minutes or more but less than 15 minutes. 15 minutes or more but less than 20 minutes. 20 minutes or more but less than 30 minutes. Asked to return at a more convenient time. Asked to leave without being invited to return. Left the office after waiting 30 minutes without being interviewed. Other. Issue 3. Did anyone in the office do any of the following for the tester? Offer something to drink, reading matter, etc. Offer literature on homes available or on home buying in general. Ask the tester to be seated. Chat with the tester informally while waiting. Other act of courtesy. What testers look for. Issue 4. Which of the following best describes the place where the tester was interviewed? A room with one or more desks and no separate rooms or partitions. A room with one or more desks separated by partitions. A private office. Other. Issue 5. Did the agent request any of the following information about the tester's housing needs? Price or price range. Size. Location by neighborhood or jurisdiction. Style or type of housing. Special features or amenities of house. Special features or amenities in neighborhood. Down payment able to make. Type of financing desired. Other. What testers look for. Tester issues of interest continue to be very specific. The tester is not simply asked, do you think you were discriminated against because of your color, sex, familial status? Instead, he or she is asked very specific questions to provide factual evidence of possible discrimination. Testers will be asked, did the agent request any information about your income? Did the agent request any information about your spouse's income? If the agent requested any of the above information, did he record any of this information or ask you to record it? Yes, on what appear to be a standard printed or duplicate form, file card, or a logbook, etc. Yes, but not on a standard printed or duplicate form, file card, logbook, etc. No. Did not record anything even though agent requested information. No, agent did not request any information. And finally, how many houses in all were volunteered to you as serious possibilities by the agent? No houses. 1 house. 2 houses. 3 houses. 4 or 5 houses. 6 or more houses. As you can see, testers are very serious and very aware of what constitutes discrimination. To prevent this, you should make it your practice to treat each buyer with the same respect, dignity, and fairness that everyone deserves. Legal responsibilities. Responsibilities of the office. Violations of fair housing laws carry penalties and fines, so brokers must be careful about avoiding these violations. Fines, hearings, and court appearances will cost a firm both time and money and will negatively impact the firm's operation. There is also the issue of the firm's reputation, which would suffer greatly if violations are filed and proven. Many errors and omissions liability policies do not cover fair housing issues. Responsibilities of the agent. Why is it important for the agent to know the law? There is more than one answer to this question. Here are a few reasons why knowing the law is necessary for a real estate professional. 1. It's the law. Real estate licensees must obey all federal, state, local rules and regulations. 2. It's right. Everyone should have an equal opportunity in our country to own or rent the property of his or her choice. 3. It reduces risk. It is risky business to attempt to violate fair housing rules. Besides the penalties, a court case and attorney fees could cost a licensee time, money, and loss of license. Other legal ramifications. As we said above, fines and penalties can cause injury to both the firm and its licensees. A court could order a non-solicitation or cease and desist order, which we will talk on the next screens. Additionally, New York allows a reinvestigation of a violation a year later, so a firm would be subject to a reinvestigation of a complaint that has already been resolved. Non-solicitation orders. A non-solicitation order is a directive to all real estate brokers and real estate salespersons to refrain from soliciting listings for the sale of residential property within a designated geographic area. Within a non-solicitation area, no real estate broker or salesperson can engage in any form of solicitation with the purpose of, directly or indirectly, obtaining a listing of residential property for sale and where the solicitation is directed at or toward a homeowner or occupant of residential property within the designated non-solicitation area. Examples of the types of solicitation that are prohibited include letters, postcards, handbills or leaflets or flyers, direct advertising delivered by mail or other service, telephone calls, door-to-door calls, postings in public places. The following is not prohibited by a non-solicitation order. Advertisements that are published in newspapers of general circulation, if all of the following are true. The newspaper has a general readership throughout the metropolitan New York City area or throughout a substantial portion of the metropolitan New York City area. The newspaper is published not less than once per week. The newspaper is sold by subscription or by individual copy and is not distributed free of charge. Cease and desist lists. The Secretary of State can and does establish cease and desist zones. Property owners within the established zone can file a cease and desist notice with the Department of State indicating that they do not desire to sell, lease or list their residential property and do not desire to be solicited to sell, lease or list their residential property. Owners that file these requests are put on a cease and desist list. The County of Bronx and the County of Queens are designated as cease and desist zones, as are parts of Kings County. The DOs can take disciplinary action against any real estate licensee who solicits property owners in these areas. Homeowners can request to be put on the cease and desist list by filling out a form that is available on the DO's website. Current lists of homeowners on the cease and desist lists are also available at the website or can be requested by mail for a fee. The lists are updated twice a year. Emotional results of housing discrimination. Housing discrimination has more than just a potential monetary and occupational impact on those who violate fair housing laws. When discrimination occurs, it can bring with it a host of emotional side effects. Divisiveness, anger, discomfort, social upheaval. When discrimination occurs, it obviously affects the person or persons who are the target of the discrimination. But it affects others as well. It is the responsibility of the real estate community to see to it that we have no part in perpetrating discrimination in our marketplace. It would hopefully be our goal that all real estate agents will renew their ongoing commitment to uphold the spirit and intent of the fair housing laws. Check your understanding. Print this screen, answer the questions and then advance to the next screen to see the answers. 1. What is testing? 2. How can testing be beneficial? 3. What is a non-solicitation order? 4. What is a cease and desist list? Check your understanding. Answers 1. What is testing? a simulated housing transaction designed to obtain evidence of differential treatment based on an individual's protected class status. 2. How can testing be beneficial? Testing, coupled with good documentation and record keeping, can clearly demonstrate a real estate agency's innocence when faced with a fair housing complaint. 3. What is a non-solicitation order? A non-solicitation order is a directive to all real estate brokers and real estate salespersons to refrain from soliciting listings for the sale of residential property within a designated geographic area. 4. What is a cease and desist list? A list of property owners who do not desire to sell, lease or list their residential property and do not desire to be solicited to sell, lease or list their residential property. Providing the right information in the world of fair housing and real estate, there certainly are myriad challenges. Every day you probably face fair housing issues, sometimes, without realizing it. Seemingly innocuous questions or comments from your buyers and sellers can open the proverbial can of worms before you know what's happened. You have to stay on your toes and be aware of what's happening. There are some typical questions that are most likely asked of you frequently, possibly even every day. So, let's discuss some of those issues and give you some help in formulating fair housing-friendly answers. We know you've probably been faced with questions that are outside your realm of expertise or knowledge. Although you likely already know this, it's best to refer such questions to people who are experts in those fields. Try to limit yourself to discussing aspects of the home, selling, buying and listing properties. For example, questions about local schools, the ethnicity in a certain area, or any similar questions should not be answered by a real estate professional. If you consistently refer buyers to experts who can answer these questions in a factual way, you can minimize your housing liability. More on answering questions. What if a buyer asks you a question about the minorities living in a specific area? It would be inappropriate and dangerous for you to answer this question. You could be in a lot of trouble for doing so. However, you could refer the buyer to experts in this field, someone who would actually be in possession of the demographics in a particular area. This way, the buyer gets a factual answer to his or her question, and not your opinion, which may or may not be a representation of the true statistics. Even if your opinion is fairly accurate, you are safest to avoid answering questions of this nature. Your opinion. If a client asks you a specific opinion question, such as, would you live in this home or this neighborhood? It is illegal to voice an opinion based on race, religion, color, national origin, sex, handicap, familial status, or any of the protected classes. It is okay to make factual statements based on various features within the home. The same applies to questions you may receive about your opinion of the neighborhood. If you make comments about the neighborhood's features in relation to their location within the city, closeness to shopping, or other benefits, that's okay. Make sure your voiced opinions do not relate in any way to race or any of the other protected classes. Questions about ethnic makeup. You may run across a buyer who is genuinely interested in living in an area where he will be surrounded by members of his own race. If someone asks for the Black or Jewish areas, what do you do? Well, for one, you need to explain to the buyer that you, ethically and legally, cannot recommend housing based upon the race, religion, color, national origin, sex, handicap, or familial status makeup of the neighborhood. Remember, selecting properties based on the ethnic makeup of the neighborhood could easily bring about a steering charge against you. Listing agreements. A real estate professional should make it clear from the beginning that his or her brokerage does take fair housing laws seriously. Before even entering into a listing agreement, a real estate professional should explain the importance of fair housing compliance and secure a commitment to this before agreeing to list the house. This way, if the seller chooses not to follow the fair housing laws, the agent or broker can refuse the listing. This discussion and the listing agreement should make it clear that the agent will observe 5 rules in dealing with the listing and resulting prospective buyers. 1. The prospective buyer will only be described in terms that do not include race, religion, color, national origin, sex, handicap, familial status, or other protected class status. 2. The prospective buyers will be identified not by name but by occupation, present residence, or other characteristics of the buyer which could not identify them as members of a protected class. 3. The facts of the offer should be carefully documented so that the broker cannot be charged with failure to present the offer in a fair and non-discriminatory manner. 4. The listing will be terminated if the seller refuses to consider an offer because the prospective buyer is a member of a protected class. 5. The supervisor and broker will be informed of any suspected attempts by the seller to illegally discriminate. Questions about buyers. Licensees should remember that anyone who has the ability to buy has the right to buy. As a real estate professional, if you are posed questions about the buyer that have nothing to do with the sale, you have to handle the situation carefully. If you are asked about the color, religion, ethnicity, familial status, or other protected class characteristics of the buyers, you must tell the seller it is inappropriate for you to give out such information. The seller cannot withhold property from a protected class individual, and the real estate professional must definitely not be involved should this happen. If so, both the seller and the agent or broker could be found in violation of the law. In the same way, the seller cannot legally decline to show a property to minorities or members of other protected classes. Both the seller and the real estate professional could be sued for violating fair housing laws. Fair housing situations. It's easy to look at the most exaggerated cases of discrimination and identify them as such. However, as we have pointed out, sometimes you might not even recognize a seemingly innocuous statement as one that is actually discriminatory. Let's look at some specific examples. In each of these situations, consider how you would respond to the questions before you read our recommended responses. Be careful. Remember, the goal is to treat everyone exactly the same, with respect and fairness. And if simply treating people the right way isn't enough reason to do so, remember that any of these individuals could be testers. Situation 1. You are an agent who has shown this house 5 times, once to a single mother, once to a pair of black males, once to a Hispanic family with 2 children, once to an elderly couple, and once to a white family of 4. The Hispanic family makes an offer and you are presenting the offer to the sellers when Mr. Seller asks, "Which buyer is this contract from?" How will you respond? Fair housing situations. Situation 1- Response. This offer is from the buyers from Akron who have both taken the teaching positions at the university. Never say, "This offer is from Mr. and Mrs. Sanchez." Remember the Hispanic couple with 2 children? Situation 2. You are the listing agent on a house. You have received an offer and are presenting it to the sellers. The offer was made by a black couple. He is a computer programmer, and she is a commodity trader. As you begin, the seller asks, "What color are they?" How do you respond? Fair housing situations. Situation 2- Responses. Before I try to answer your question, I need to know why you're asking it. If you remember, when I listed your property we discussed and I pointed out to you that the listing agreement provides that this property is offered without regard to color. If you intend to violate that agreement, I need to know now so that we can save each other a great deal of litigation and liability. I must protect myself, my company, and hopefully also protect you. Or you could say the following: under the terms of our listing agreement and under the law, I am reluctant to ask the buyer's agent that question or try to answer it. The color of the prospective buyer has nothing to do with your desire to sell your property at the asking price and under terms you consider fair. If you want the terms of this listing to be based on selling it to a person of a certain race, then frankly, we can't represent you and no other real estate broker in town can legally do so and keep his or her real estate license. Fair housing situations. In this type of circumstance described in Situation 2, You should also add the following. Mr. Seller, I don't want to answer that question, because whatever answer I give you will make the marketing of your property a great deal more complicated and costly for both of us. You and I are both obligated by law to offer your property without regard to color. If I answer your question, how are we ever going to be able to prove that we have fulfilled our legal obligations? Whether the buyer is black, white, or some other color, we will have a lot of trouble proving that race was not a factor in your final decision to sell. And really, it should not be a factor at all. Selling your home at a price and under the terms agreeable to you is the real issue here. Situation 3. Buyers Mr. and Mrs. Ruiz are Hispanic. They are financially qualified and have made an offer within $1,000 of the asking price. You have shown the house a number of times and believe that an offer from the O'Briens may be forthcoming. As you present the offer to the sellers, Mrs. Seller asks, "Can't I wait for Mr. and Mrs. O'Brien to make an offer? The Ruiz family just doesn't seem to be the type one want to sell my home to." How do you respond? Fair housing situations. Situation 3- Response. I do not understand why you don't believe Mr. and Mrs. Ruiz are the type you want to buy your home. They have made a good offer and are financially qualified. What type are you looking for? Explaining this response. If the response to your question reveals the seller is looking for a non-minority home buyer, you should advise the seller of his legal and contractual obligation not to discriminate. It is best to clear up any doubts as to the seller's intention, rather than leave the situation ambiguous. Mr. Seller, I certainly appreciate your desire to have the opportunity to consider all offers, and I will try to get a firm offer from the O'Briens immediately. But the Ruiz's offer is a good offer, and I would hate to see you lose out by delaying. Also, I really don't understand why you consider the Ruiz family the wrong type of buyers for your home. Fair housing situations. When the basis for deferring a decision is ambiguous but could be discriminatory, it is important that you or your broker attempt to remove the ambiguity by forcing the seller to articulate his or her concerns. If the concerns are founded in bias, you can take action to remove or overcome the bias or repudiate any support for it. On the other hand, the seller's concern may be the product of considerations or impressions which you or your broker can either clear up or explain in non-discriminatory terms. Situation 4. Mr. Jones, the prospective buyer, is black. The house has been shown only 3 times in 3 months, and no one else seems interested. You are presenting an offer from Mr. Jones to the sellers, and Mr. Seller asks, "If I take my home off the market, how long do I have to wait before I can sell it again?" How do you respond? Fair housing situations. Situation 4- Responses. Mr. Seller, you must understand that if you withdraw this property in order to avoid selling it to Mr. Jones, a black man, you risk serious legal liability and you may be unable to sell your property indefinitely. I strongly suggest you consult with an attorney before you take this action. As for my firm and me, I certainly cannot agree to the termination of our listing agreement for this reason. Or you could say, "Mr. Seller, I am very uncomfortable with your decision to withdraw your property from the market. I realize this is your decision, but I am concerned that it will appear to be merely an excuse not to sell to Mr. Jones because he is black." One solution to this problem could be to tell the seller the following: "Mr. Seller, I don't understand the reasons you feel you need to withdraw your property from the market. However, Mr. Jones may feel that your reasons are merely an excuse for not accepting his offer because he is black. I think it would be helpful to you and Mr. Jones, and it may also avoid hard feelings, misunderstandings, and possible litigation, if I brought Mr. Jones by and let you explain your decision to him personally. Encouraging a face-to-face meeting might be the best option for everyone involved." Fair housing situations. Face-to-face meetings between sellers and prospective minority buyers have several values. 1. The broker is relieved of the problem of articulating the seller's reasons for withdrawal. 2. The prospective buyer is able to see that it is the seller and not the broker who has made the decision. 3. The mere bringing of seller and buyer together for a final discussion supports the objective role of the broker. 4. The prospect of confrontation may well discourage the seller whose reasons for withdrawing the property are not substantial or honest. Situation 5. You are trying to list a home that is in a white pocket community in a mixed-race county. After going over all your research and deciding on an agreeable price for the seller's home, they decide they definitely want to list the home with you. Before you can get them to sign the listing agreement, Mrs. Seller says, "Are you aware that there is a bonus if you can sell my home to the right people?" How do you respond? Fair housing situations. Situation 5- Responses. I appreciate the offer of a bonus, but it would be both unethical and illegal for me to accept it if it is conditioned on the race, national origin, religion, handicap, familial status, or sex of a buyer I am able to bring you. Such an arrangement would subject both of us to very serious liability. Or you could say, your offer of a bonus for bringing you offers from the right people is inconsistent with our agreement. The agreement stipulates I am to market your property without regard to race, religion, national origin, handicap, familial status, or sex of the home seeker. I must insist on holding to our agreement. Situation 6. The seller is an elderly black college professor who lives in an upper-class section of town. She is interested in seeing that the neighborhood stays integrated. Just as you are about to list her home, the owner asks, "Why must I sell my house to people I don't like, white or black? Why don't I have freedom of choice? How about my rights?" How do you respond? Fair housing situations. Situation 6- Response. Miss Seller, I don't think it is appropriate for me to try to answer these questions for you. If you believe you have the right to discriminate on the basis of race, religion, national origin, handicap, familial status, or sex, I must urge you to have a talk with an attorney. From my standpoint, and that of my firm, we know we are prohibited by law and by our code of ethics from marketing property on a discriminatory basis. Moreover, it is difficult for us to understand how people can dislike a whole class of people. How can someone hate you without knowing you? What does being Jewish have to do with being a good neighbor? What does being Italian have to do with the price you want for your property? We can do a good job of selling your property to a qualified buyer at the price and on the terms you specify. But we cannot do that job unless we have your consent and support to market your property on a non-discriminatory basis. Situation 7. You are an agent that specializes in the south side of a major metropolitan area. A family of Asian descent walks into your open house and asks, "What is the racial composition of this neighborhood?" How do you respond? Fair housing situations. Situation 7- Response. We have a host of demographic information back at the office. You can review it any time you wish. It would not be wise for me to guess. If you would like to research this matter, I have the telephone numbers of the City Planning Department and the Bureau of Census. They have additional information. We do not keep statistics based on race, color, religion, nation origin, sex, familial status or handicap at our office. Situation 8. You are an agent that serves a wide, rural area. A would-be buyer walks in your office, approaches you, and says, "As you can see, I am black. Do you service any areas where I would feel at home?" How do you respond? Fair housing situations. Situation 8- Response. We have access to houses for sale in many areas. If you can tell me some of the features you are looking for in either your house or neighborhood, I can help you out. Are there any particular villages or towns in which you would like to start your search? Most of the villages have houses in several price ranges, and the houses tend to vary quite a bit in style and age. Once I know what you're looking for, I will be in a better position to let you know what is available that meets your criteria and to help you find the house in the area that you want. Situation 9. You serve an area with homes owned by a wide variety of races, ages, and religions. Your own children attend a school that is 60% white, 20% black, 10% Hispanic, and a 10% mix of American Indian and Asian. Mr. and Mrs. Smith are out looking at houses and stop by your office to inquire of saleable homes in your area. While qualifying them, Mr. Smith asks, "Are the schools integrated?" How do you respond? Fair housing situations. Situation 9 response. Our office does not maintain statistics regarding the racial makeup of the student body in the schools in our market area. If you would like such information, you should contact either the school itself or the school district's office. Those sources can also tell you which schools will be available to your children, the class size, and the basic curriculum, and provide the best answers to your questions. Also, you might want to check with some of your potential new neighbors about how they feel about the schools their children attend. Or you could say, "Mr. Buyer, the only school I'm really familiar with is the one my own children attend. Since I don't have personal experience with the others, I cannot give you the complete information you really want and need. Let me refer you to the school district office, which can give you information about curriculum, class size, and the names of the schools which service the various neighborhoods in which you are interested." Situation 10. You work for Peaceful Valley Realty. You service urban, suburban, and rural areas. There are pockets of high crime in the urban areas. The suburbs tend not to suffer from major crimes such as murder and armed theft, but they do have their share of purse snatching, shoplifting, and home break-ins. Some adult communities in your area have walls and security guards. Mr. and Mrs. Elderly walk into your office, both of whom appear to be in their late 70s. Mrs. Elderly requests, "Why don't you just pick out some nice properties in a safe area for us?" How do you respond? Fair housing situations. Situation 10 response. We have many homes in our market area to choose from. Perhaps we should inspect a few to see which ones best fit your needs. Or you could say, "Our office does not compile crime statistics. Let's go through our multiple listing of homes and select some that fit your requirements. While we are out inspecting homes, we can stop at the village police department if you would like to. Also, I can put you in touch with several security services that would undoubtedly be able to discuss your concerns in depth." Situation 11. You are out with a prospect in an area much like your own community, but closer to the river. There is a home under consideration in a relatively new subdivision, and your home is only 5 miles away in an older neighborhood with many mature trees setting on larger lots than the subject property. You do not have any school-aged children, but your prospects do. Mr. Prospect asks, "Would you live in this neighborhood?" How do you respond? Fair housing situations. Situation 11 response. Yes, I would. The area is well maintained and that particular house is very nicely located. It is very convenient to the commuter trains, shopping, and the elementary school is only a few blocks away. Situation 12. You are working with buyers, and they are second-generation Japanese. They have 2 small children and are both professional people. They walk into your office and ask, "Could you please suggest some good areas? We are new to your state and would like some help." How do you respond? Fair housing situations. Situation 12 response. We feel that all the areas in which we do business have many positive features. The communities, style and price of housing do vary. However, what did you have in mind? Do you have any particular needs in a house? Or you could say, "We are very positive about all the areas we service. Each community has its own particular charm and, of course, no place in the world is perfect." What size and style of home are you looking for? Are you familiar with any of the communities we have listings in? Have you had any opportunity to drive around the area? Would you allow me the privilege of showing you and your children the area where I sell homes? Will you be working in this area? These situations we have presented on the previous screens are not all-inclusive, naturally, but rather, were designed to get you thinking. Did you find the responses respectful to all involved parties? Can you picture yourself using the appropriate responses in similar situations? If not, it's time to analyze what you would say, or what you have said, in instances like the ones presented. Risk reduction in fair housing. To protect yourself and your agency, it's best to be consistent in your work and how you treat people, black, white, young, old, those with children or without, disabled or not disabled. All persons with whom you work should receive the same professional care and caring demeanor that a real estate professional is expected to deliver. If you follow these rules, you will greatly reduce your risk in dealing with fair housing issues. 1. Know your job. 2. Know the law. 3. Sell the seller. 4. Practice equal professional service. 5. Keep good records. 6. Be consistent in behavior, service, paperwork. 7. Keep up to date with law changes. Summary review. This concludes Chapter 21. Below is a summary which you can review before taking your quiz. Brokers have a responsibility to comply with fair housing policies. They must maintain a fair housing office. Licensees share in the responsibility of complying with fair housing laws. Fair housing law first began with the Civil Rights Act of 1866, which prohibited discrimination in housing based on race. The Fair Housing Act of 1968 prohibited discrimination in housing based on race, color, religion or national origin. Jones v. Mayer ruled that discrimination on the basis of race is strictly prohibited. This means there can be no exemptions or exceptions with regard to race. In 1974, the Housing and Community Development Act added sex to the list of protected classes. And in 1988, the Fair Housing Amendments Act added handicap and familial status. Any person who believes he or she has been discriminated against may file a complaint with HUD within 1 year of the alleged act. In addition to, or instead of filing a complaint with HUD, a person may file a suit in a state or federal court within 2 years of the alleged violation. Summary review. Summary federal laws such as Plessy v. Ferguson, Buchanan v. Worley, and Brown v. Board of Education played an important role in helping to shape American civil rights policy after the passage of the original Civil Rights Act of 1866. The Americans with Disabilities Act, which became effective in 1992, mandates that persons with disabilities have equal access to jobs, public accommodations, government services, public transportation and telecommunications. Since most real estate firms are public places, brokers should evaluate how this applies to physical changes they might need to make to their office space to accommodate both employees and clients. Article 15 of the NYS Human Rights Law prohibits discrimination in employment, housing, credit, places of public accommodations, and educational institutions. In addition to the classes protected under the federal laws, New York has added other protected classes. Age, marital status, military status, sexual orientation. The New York City Human Rights Law is one of the most comprehensive civil rights laws in the nation. The New York City Commission on Human Rights has identified 3 other protected groups: alien age or citizenship status, lawful occupation, partnership status. Summary review. Summary discriminatory activities in real estate include refusing to sell, rent or negotiate with any person who is a member of a protected class. Fair housing laws also prohibit these activities. Blockbusting, making a profit by inducing owners to sell by telling them that persons of a protected class are moving into the neighborhood, which will have detrimental results. Steering, channeling home buyers toward or away from homes in certain neighborhoods in order to preserve or alter the makeup of that neighborhood. Redlining, restricting the number of loans in certain areas of a community because of its racial or ethnic makeup. Compliance with anti-discrimination laws is critical when doing advertising. Private fair housing groups, along with government agencies, have developed an investigative tool called testing to uncover housing discrimination. Testers with similar profiles and housing needs, but different in their protected class status, visit a real estate office and ask to see the same available unit to ascertain if they are treated differently because of this protected class status. Summary review. Summary: violations of fair housing laws carry penalties and fines, so brokers must be careful about avoiding these violations. A court could order a non-solicitation order or a cease and desist order. A non-solicitation order is a directive to all real estate brokers and real estate salespersons to refrain from soliciting listings for the sale of residential property within a designated geographic area. Property owners within an established cease and desist zone can file a cease and desist notice with the Department of State indicating that they do not desire to sell, lease or list their residential property and do not desire to be solicited to sell, lease or list their residential property. When faced with questions that are outside your realm of expertise or knowledge, it's best to refer such questions to people who are experts in the appropriate fields. Try to limit yourself to discussing aspects of the home, selling, buying and listing properties. Click here if you would like to open this summary as a PDF, which you can then print or save to your device. Chapter 21 Summary Chapter Conclusion. In this chapter, we have discussed the federal fair housing laws and what they cover. New York State Fair Housing Laws. Types of discrimination. A broker's responsibility in maintaining a fair housing office. The salesperson's responsibility to know and follow fair housing laws. In the next chapter we'll cover real estate mathematics. Now it's time for your chapter quiz. Good luck! 1 of 19. When would a model home in a real estate development need to comply with the ADA? When it is used as a development sales office. 2 of 19. A client asks you the following specific question: would you live in this home or this neighborhood? How should you answer? By focusing on factual statements based on various features within the home. 3 of 19. Which section of the NYS human rights law prohibits discrimination in employment, housing, credit, places of public accommodations, and educational institutions? Article 15. 4 of 19. It is probably safe to say that any advertising that would be considered acceptable the property. 5 of 19. Which of the following is not a protected class under the Federal Fair Housing Act? Financial status. 6 of 19. When a complaint of discrimination has been received, HUD will make a determination within if there is cause to charge discrimination or if the complaint is to be dismissed. 100 days. 7 of 19. The seller cannot legally decline to show a property to minorities or members of other protected classes. If this happens, both the seller and the real estate professional could be sued for violating fair housing laws. 8 of 19. Any person who believes that he or she has been a victim of discrimination can file a complaint within 1 year of the alleged discrimination. The New York Division of Human Rights. 9 of 19. Testing for fair housing compliance must report findings to HUD and your broker. 10 of 19. Which state was first to enact a human rights law? New York. 11 of 19. What legislation mandates that persons with disabilities have equal access to jobs, public accommodations, government services, public transportation and telecommunications? Americans with Disabilities Act. 12 of 19. If a buyer asks for the Jewish area, what do? Explain to the buyer that you, ethically and legally, cannot recommend housing based on religion. 13 of 19. Which law added gender as a class protected against discrimination? Housing and Community Development Act. 14 of 19. Which additional protected class was not added by the New York City Commission on Human Rights? Perceived sexual orientation. 15 of 19. Which of the following is not prohibited by a non-solicitation order? Advertisements in the newspaper. 16 of 19. Restricting the number of loans in certain areas of a community because of its racial or ethnic makeup is known as redlining. 17 of 19. In a process known as dwellings that were formerly occupied by middle and upper income families decline in quality and value and become available to lower income families. Filtering down. 18 of 19 Terry and her 2 children want to rent an apartment in a quiet 10-unit apartment building where 8 of the apartments are currently occupied by retired couples over 60 years old. Tom, the building owner, has refused to rent to Terry. Tom has the right to refuse to rent to Terry and her children because his building qualifies as housing for older persons. 19 of 19 New York's human rights law prohibits discrimination in the obtaining of credit.